This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing and Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
It is Wednesday, which means it is time to ask Todd any estate planning question that you have. Give our studio number a call at 888-205-2263 to ask our attorney here, Todd Lutsky, anything that you want in the estate planning realm, free of charge. He will not send you a bill for this consultation. Again, that number here is 888-205-2263. I will ask Todd the first question. Todd, how are we doing today?
I am never better than you.
I'm doing very well. It is the holiday season, Todd. Believe it or not, my wife has already put up some Christmas decorations. Don't throw anything at me, but it's just a fact of life. And that means a lot of people are thinking about gifting. What is the number that a grandparent or a parent could gift to any grandchild or child that would permit them from not having to file a gift tax return?
I think there's a lot of questions wrapped up into that one question, believe it or not. I'm going to expand on it a little bit because I think when people think about gifting, there's lots to think about. This is just one issue. You know, the gift tax or the income tax, right? And so let's focus on that for a minute. So first and foremost, there is no income tax associated with a gift. No direct income tax.
Right.
What I mean by that is the giver doesn't pay an income tax and the recipient doesn't pay an income tax. Now, I say that's not entirely true because if you give away, let's say you bought stock for $100 years ago and it was ballooned now and now it's worth $1 million.
Mm-hmm.
Well, now there's 900,000, 909,000. Let's say you paid $100,000, it's worth $1 million. There's now $900,000 of gain. If I give that stock away, there's no income tax on the gift itself. But when that recipient goes to sell that stock, they're going to have a capital gain.
Sure.
Because you gave them the gain when you gave them the stock. Okay, so be careful about that aspect of it. But otherwise, there's no income tax. What about the gift tax, which is really where you were headed, Paul? On the gift tax side, the recipient, regardless of the amount, never pays a gift tax.
Right.
That's nice. And who does? Well, the giver. No good deed goes unpunished, is what I like to say. So the giver is the one that needs to look out for the gift tax. Now, a couple of things. Federal and state gift tax. There is no gift tax at the state level except Connecticut. Mm-hmm. It's the only one that you have to think about, Connecticut. Okay, so we don't have to worry about that. Secondly, there's a federal gift tax. Okay, well, when does that kick in and how does it work? Well, the federal gift tax would kick in when you make a gift, an outright gift of more than what they call the present interest exclusion amount, which as of now is $16,000 per year per person. But come 2023, it is going up to $17,000 per year per person. For all of you out there, you remember it used to be 10. That was the big number.
Right.
So that means as long as you give away $16,000 to anybody once a year, you don't file a gift tax return and you don't pay any gift tax. Period.
So you can give Tucker and myself $16,000 each. No gift tax needs to be filed.
Nothing needs to be filed. It's what I like to call a complete freebie.
Perfect.
Okay? But let's do an example. Let's say I gave away, and if you're married, you could do 16 times 2.
Right.
Husband, wife. So double it.
Mm-hmm.
But let's say I gave away $500,000. It would be $500,000 minus $16,000 because that's my present interest exclusion amount. And the delta is the taxable gift. Now I need to file a gift tax return, the giver.
Mm-hmm.
And I'm not going to pay any gift tax, folks, because I have a $12,060,000 current gift tax exemption that I nibble away at each time I make a taxable gift. So while I need to file, I don't necessarily need to pay. And folks, having said that, there's so many other things to think about in the gifting world. Don't just give away your assets.
There's a lot there. We're talking with Todd Lutsky here. If you want to give us a call and ask Todd anything in the estate planning realm, any question that you may have, give our studio line a call at 888-205-2263. Again, that's 888-205-2263. Todd, another question that comes up if you have elderly parents sometimes where the nursing home may be upon them soon. And let's say, for example, they bought a home in the suburban area here, Milton, Massachusetts. They bought it in 1970. And oftentimes I've heard from the kids, hey, why don't we sell the home to help out mom or dad in order to raise some funds for a potential nursing home stay? What are some of the pitfalls that people might not be aware of by selling that home that the parents have owned for a substantial period of time?
Yeah, I don't think selling the home is a great idea, especially to pay for a nursing home, because a nursing home, you can't get your house to begin with if it's your primary residence, so it's non-countable. Plus, you're trapping, you're paying all that capital gains tax.
Right.
I don't know how much it's grown, but depending on if it's over the exemption amount. So if you're married, there's a $500,000 exemption, and there's a $250,000 exemption if you're single. But if we're talking about a gain larger than that, why do we want to incur the gain when we could wait and die owning it, and then the children can sell it with a step up in basis and pay no capital gains tax? So that step up in basis is another implication of gifting that you need to be aware of before you give.
Certainly. We've got Dan in Andover. Dan, what's your question for Todd?
Oh, hi, Todd. You have your home in an irrevocable trust.
Okay.
You pass away.
Mm-hmm.
Your heirs inherit the home, of course.
Mm-hmm.
Do they have to pay a capital gains on the inheritance?
Great question. So again, this is all exactly what we're talking about in our guide. To gift or not to gift, what is the ramifications? When I set up, or at least Cushing and Dolan, the trust we do, when we set up these irrevocable, I'm going to call it a Medicaid trust, we design it so that it's an incomplete gift for gift tax purposes, right? This is what you don't even think that when you're setting up this irrevocable trust, whether you're making a gift or not. But in this case, we design it so that it's an incomplete gift, and we give like if it's you, Dan, we would give you, or the creator of the trust, a lot of control over the document, over the trust. So that makes it an incomplete gift. And so when you die, the asset is still considered yours. It's still considered part of your estate. Now, it does avoid probate, so we don't have to worry about that. That's something we always want to do. So we would have avoided probate, but it would be included in the estate. Now, the effect of the inclusion. When it's included, it's going to be subject to the death tax. So if you're over the $1 million, there's a Massachusetts death tax. If you're under the $12 million, there's no federal estate tax. So it's very likely that you can have inclusion and pay no death tax. But the benefit of the inclusion is you now get a step up in basis, and that's what you were referring to, Dan. So when they get it, they may pay, not only will your heirs possibly pay no death tax when they get the house, they could turn around the next day and flip it and sell it and take the money and pay no capital gains tax. So you could win on both the income side and the estate side, because what a step up in basis means is if the property was worth $500,000 on the date of death, it's as if they paid $500,000 due to this step up in basis. So you just got to read the document that you guys prepared and make sure that it's an incomplete gift and that you're going to have inclusion on the date of death. I know all of our trusts will get you there. So that is a huge win and a great question. So, but let me tell you about this, because this is exactly what's in our guide, folks, to gift or not to gift, right? When you think about gifting, this would be one very important question to ask. Do I want to gift something away that has a large built-in gain? Maybe Dan bought this house, a year or years and years ago, and there's huge gain in it. Well, that would not be a good idea to gift. I would want to keep that to get the step up. I might want to give something away that has a much higher basis, or maybe something, if it's going to save me estate taxes, that would grow quickly. And remember, folks, sometimes you don't want to gift at all, because by not gifting, you're better off. And if you are going to gift, maybe you want to gift to a trust and not give it outright to your children, and you can protect it from creditors. There's Medicaid implications of gifting. Folks, get the guide. To gift or not to gift, learn the best ways to do it and when and how. 866-848-5699 is the number, or go to legalexchangeshow.com. You can download the guide there. Again, 866-848-5699 or legalexchangeshow.com.
We're now going to take a question from our second caller here. Phil in Rhode Island. You're up next with Todd Lutsky.
Yes. Hi. Thanks for taking my call.
Sure.
So it's a little complicated, but I want to try to put it in a nutshell. When I was in 1972, when I was a young man working at McDonald's, I bought stock in the company.
Great.
I held on to it till about 3 years ago.
Awesome.
And I went to go cash it in.
Mm-hmm.
McDonald's, we don't know you. We don't have any record of it. Anyway, long story short, after going through like all kinds of stonewalling with McDonald's, I had to hire an attorney who threatened and actually filed in federal court. And after all of that, they finally agreed to give me half of what I was entitled to.
Okay.
Anyway, so the money went to the attorney, and then the attorney paid me.
Yep.
In my portion after he took his third. I was a little upset that I had to give a third of what I had.
But hurry up, get to the question.
Yeah, the question I was trying to get to is, so how am I? If it was just stock, and I turned it in and took the gain, I would pay one way. But if they're going to treat it as income, is it going to be totally different?
Well, the problem is I don't know how they're going to treat it, number one. It's just we're never going to be able to, I'm not going to be able to answer that question today. To me, there should be no question. To me, if it was deemed that you own stock and that you held it for more than 12 months and you've sold the stock resulting in whatever money you got, you should be responsible for the gain. And it should be considered long-term capital gain. And so, therefore, you should be paying, tax at the 20% federal, 5% state, and 3.8% Obamacare tax. So that would be my position. Talk to your accountant, figure out how that can work out. But that's an interesting spot.
And that's all we've got today for Ask Todd. Todd, thanks so much for joining us. Really appreciate it.
Always a pleasure.